Hearing the appeal, Alphamix Ltd against the District Council of Rivière du Rempart.
Mr. Grayson.
May it please your Lordship, I appear on behalf of the appellant, Alphamix, alongside Ms. Anne-Sophie Julien, Mr. Thomas Granier, I should have said Anne-Sophie Julien from the Mauritian and the English bars, Mr. Thomas Granier from the Paris bar, representing Respondent, the District Council of Rivière du Rempart, our learned friend, Mr. Patrice Doger de Spéville, Senior Counsel of the Mauritian bar, Mr. Imtihaz Mamoji, Ms. Adila Mouchrin Luto, and sitting behind Mr. Jean-Jacques Robert.
Thank you very much. Well, we've had an opportunity to read the various cases that you've submitted, the written cases and the translations. Are you able to assist us at the outset as to what extent the various translations you've given us are agreed or not agreed?
Indeed, my Lord. I was about to turn to that. First of all, the summaries of the cases, which are summaries and not translations, but they're not particularly brief summaries because the cases themselves are fairly brief. Those have been agreed by both sides and various. On the other hand, the translations, and this time they are translations of the commentaries, what in French is called the doctrine, those were sent on Monday to my learned friend, and shortly before being sent to your Lordships. My learned friend has not had an opportunity to comment on those yet, so those are not agreed.
But there's no objection to us having been referred to them in the meantime?
Yes, my Lord, I have no objection. However, I reserve my right to review it in due course, given that I presume that the appeal will, the judgment will be reserved, and I will send it very shortly if I've got any modifications to make to them. But I haven't had time since last Monday evening. I
understand. Thank you very much.
And my Lord, of course, we have no objection whatsoever to that. My Lord, as you know, this matter relates to an arbitral award rendered by a Mauritian judge acting as arbitrator in relation to a construction project awarded to Alphamix by the District Council in 2003.
Yes.
The dates, and I know you're already aware of this, but I think it's helpful to take your Lordships very briefly through this in any case. The dates are set out in the agreed chronology, which you'll find at page 376 of the electronic bundle. And you will see there that the dispute arose in 2009, that numerous awards were rendered by two arbitrators. The first one resigned in 2014 after having rendered 3 partial awards and was then replaced by the judge, the arbitrator in this case, in 2015. This appeal, my lords, concerns the fourth and last of the awards, which was rendered, depending on your decision in this appeal, on either the 31st of December 2018, according to us, or on the 3rd of January 2019, according to my learned friend.
Yes.
And in that final award, as your lordships know, the arbitrator awarded interest to Alphamix, to the appellant.
And what follows if it wasn't delivered until, or given until the 3rd of January?
Well, if it wasn't given until the 3rd of January, then we lose on our primary case, on which I will be making submissions to you this morning. But we then have our alternative case that there was either a tacit agreement or a waiver.
Oh, sorry. What I was really asking was what happens if the award is a nullity?
Oh, I'm so sorry. If the award is a nullity...
In other words, if the respondents succeed, what is the consequence, the legal consequence?
The legal consequence is that my client is entitled to bring a fresh arbitration, subject, of course, to any points of limitation. But that would be...
So start all over again?
Indeed.
Right.
A dispute that has been going on since 2009.
But there's no bar to starting a fresh, bringing a fresh arbitration?
There is no bar subject to questions of limitation. There is no other procedural bar, and I'm not aware of any limitation point, but of course this hasn't been read.
No. Yep.
Thank you very much. So I think you're going to divide up your submissions on behalf of the appellant into various sections, is that?
Into two sections, if that is convenient to your lordships. The primary, and I'll explain this in a moment, the primary case I will address you on, and I'll also before that be talking about the procedural issues about the grounds of appeal, and then Ms. Julienne will be dealing with the alternative case, which is about the tacit agreement and/or waiver. So the date, my lords, is, as you know, important because the deadline for rendering the award was the 31st of December 2018. That was a deadline that had itself been extended from the 28th of October 2015, no fewer than 8 times, and you can see that on page 377 of the electronic bundle, which is the second page of the chronology. On the 18th of December 2018, the arbitrator fixed 27th of December 2018 as the date on which he would now render the award. That was then pushed back by the arbitrator to the 28th of December, the next day, and then to the 31st of December at 10 a.m. That you see on the next page, page 378 of the electronic bundle. 10 a.m. was then pushed back to midday, and then to 1:10 p.m. Again, this is all in the agreed chronology.
Well, you can see from entry number 24 that the arbitrator is well aware of the mandate when it expires.
Absolutely. Absolutely. There was no doubt about that at all. Exactly. Now, at this point, that's to say at 1:10 p.m. on the 31st of December, the parties were received by the arbitrator, who asked them whether they agreed to his reading only the introductive and operative parts of the award, to which they agreed. He told them that they would receive an unedited version of the award, and that, and I quote, an edited version of the award will be provided later on, which would not change anything in his findings. Again, the parties said they had no objection. Shortly afterwards, at 1:56 p.m., the arbitrator's secretary sent a copy of an unedited and unsigned version of the award to the parties and wished them a happy new year. There were then no further communications between the arbitrator and the parties on that day, which was again the 31st of December. On the 3rd of January 2019, which was the first working day after New Year's Day, the arbitrator's secretary issued minutes observing that, and I quote, with agreement of parties, a formatted, edited, and signed version of the final award is now being filed. And at 1:28 p.m., the arbitrator's secretary sent the parties an email telling them that a copy of the formatted, edited, and signed version of the award delivered on the 31st of December 2018 in the above arbitration is now ready, and you may collect same with me. That's recorded on page 379, the final page of the chronology. On the 22nd of January 2019, Respondent applied to the Mauritian Supreme Court to annul the award, which the Supreme Court did 2 years later on the 14th of January 2022. And it is, of course, against that judgment that Alphamix is now appealing to your Lords. My Lords, thanks to the parties' written cases, it has become clear that there are really only 2, possibly 3 issues before you today. The first is whether the award was rendered for the purposes of meeting the deadline on the 31st of December 2018 or on the 3rd of January 2019, which in turn raises the question whether under Mauritian domestic arbitration law, an arbitral award is rendered when it's signed or when it's communicated to the parties. And it also raises the issue of when, in fact, the award was signed. The second issue, which perhaps is in fact two separate issues, that's why I said it was perhaps 2 or 3 issues. The second issue is this, that if you find against us that the award was rendered on the 3rd of January 2019, did the parties tacitly agree to extend the deadline to waive the right to rely on the failure to meet the deadline? And again, this could be 2 issues because there's a difference between tacit agreement and waiver, which Ms. Julienne will be addressing your lordships on in due course. As I said, I will be addressing your lordships on the first point, our primary case, and Ms. Julienne will be addressing your lordships on the alternative case. Now, before turning to the first point, I should, if I may, address your lordships on the procedural points that have been made by the District Council in relation to the grounds and the arguments relied upon in our written case. And those arguments, your lordships will find at pages 422 et sec of the electronic bundle, which is from their written case. And what they say there, my lords, is that it is 2 things. First of all, that the grounds in our written case are different from the grounds in our leave application. And secondly, they say we made a couple of arguments that were not made before the Supreme Court of Mauritius in relation to the annulment application, or in the context of the annulment application. Dealing first with that first point, I would ask your lordships to look at page 422, the one I just referred to a moment ago, 422 of the electronic bundle. As I said, this is from the respondent's written case, and it sets out very helpfully and very fairly the grounds of appeal from the leave application, that's at paragraph 6, and then those from our written case at paragraph 7. So that's a convenient way to compare the two groups of grounds. And if I may, I'll take your lordships.
It's a pretty sterile exercise, this. I'm not sure whether we need to spend time examining the nuances of difference. I mean, they're basically the same points dressed up a different way, aren't they?
That's what I was going to say, and if your lordships are happy for me to
what in substance were you going to draw our attention to?
I was going to match up, but I have the impression that your lordships have already done it. Match up the grounds.
You should not assume that we're all of the same mind about every issue. So if you don't need to labour it because we've got the documents in front of us, but
I will not
just highlight for us any particular points to which you'd like to draw our attention.
I would do it as quickly as possible, but I recognise it is a fairly sterile exercise, yes. But I'll do it quickly. If you look first at paragraph 7, so on page 423 of the electronic bundle, these are the grounds that we put forward in the written case, in our written case. Ground A, very simply, is ground G of the grounds in the notice, which you find slightly higher up the page,
yes.
At page 423.
Yeah, we've got that. Thank you.
So, very minor, inconsequential changes. Ground B is ground A of B in paragraph 7 is ground A in paragraph 6.
Yep.
Exactly the same, except that it omits the words "or delivered." Ground D is indeed the same as ground D in paragraph 6. Exactly the same, except that it omits the wording "given that the signed copy of the award dated 31st December 2018 was on record before the Supreme Court." Grounds E and G, again in paragraph 7, are in fact exactly the same, and they are also the same as ground E in paragraph 6, no difference whatsoever. And ground H in paragraph 7 is the same as ground H in paragraph 6, very slightly different wording, but nothing material. So
you've adopted the observation of my lord, and we can see now how they match up, and certainly for my part, that's enough at this stage, unless there's any particular point you want to for us.
Nothing at all. That was all I was seeking to do, and I'm glad that it's...
But those are the only grounds, are they? The grounds aren't reflected.
The grounds in paragraph 7 are indeed our only grounds. So we have indeed, my Lord, dropped certain grounds as they had been previously set out.
Right.
So the purpose of that was simply, and I hope it's been efficient, was simply to show that there's nothing in our written case that is new compared with the leave application.
Yep.
All we've done is to withdraw certain grounds, delete a bit of wording, and change the numbering in a way that I fully recognise is confusing and unhelpful, and we apologise for wasting time with that, my Lord. That is all I was proposing to say about the first point, which is that there's a difference between the grounds. So turning to the District Council's second point, you find that, my Lords, at page 430 of the bundle. Paragraph 29 of the respondent's written case. This is in relation to our primary argument, in other words, that the award was in fact signed on the 31st of December 2018, and they say there the appellant has embarked on submissions before the board which are different with those made before the Supreme Court.
Yes.
And then if you turn on, I'll come back to this moment, if you turn on to to page 436 of the written case, 436 of the bundle, which is page 18 of the written case, and to paragraphs 42 and 43, what they say there in relation to our alternative argument, the one which Ms. Julienne will be addressing your lordships on, about the extension of the deadline of the waiver. They say appellant's written case canvasses extensively the issue of express judicial contract, which does not form part of the grounds of appeal and never made an issue before the Supreme Court. Furthermore, it's submitted that tacite prorogation were not argued by the appellant before the Supreme Court in the annulment proceedings. I skipped some words. The respondent, therefore, reiterates the submissions made at paragraphs 29 to 34 above, and paragraph 29 is the one I referred your lordships to a moment ago. My lords, what we propose to do is... excuse me. What we propose to do is to respond to this procedural argument when we deal with each of our arguments.
Very good.
So I will deal with the one relating to the primary case, and Ms. Julienne will deal with the one relating to the alternative case. So with that, my lords, I will now turn to the primary case, which is, just to remind you, that the award was signed and therefore rendered on the 31st of December 2018.
Was that argued in front of the Supreme Court?
Indeed, that is what I was just about to say. It was indeed an argument that was made not by my client, but by the co-respondent who was the arbitrator.
Yeah.
And I was going to take your lordships to that just now, in fact, which is that to say that it is not in fact a new point. It was raised before the Supreme Court of Mauritius. Admittedly not by us, but by the arbitrator as co-respondent in the annulment proceedings. And you get that, my lords, from page 187 of the written bundle, of the electronic bundle. There you find the written submissions of the co-respondent who was the arbitrator. And if you turn on a few pages to page 195, page 9 of his submissions, you will find at paragraph 26, the second paragraph on that page, the last page of the award shows that the award was signed on the 31st of December 2018. The award was therefore made within the mandate of the arbitrator, i.e. on or before 31st of December 2018. So that argument was squarely before the Mauritian Supreme Court.
Does it matter that the arbitrator ceased to be a party?
We would submit not. The argument was aired before the Supreme Court. Whether or not he was then put out of cause or not. And this argument was these submissions were clearly before the Supreme Court of Mauritius. Yes, Ms. Julien reminds me helpfully that the submission was, of course, put before the court before the arbitrator was put out of course.
Yeah.
Now, even if your lordships were, in spite of what I've just submitted, to treat this as a new point, we would ask you to allow us to raise it nevertheless. We would submit that it falls within the exceptions in the board's case law concerning new points. First of all, it is incapable of depending on an appreciation of matters of evidence. As I'll explain, we rely on two rules of law, of French law, which applies, as I'll explain in a moment, in Mauritian domestic arbitration law. First of all, that an award is rendered on the date when it's signed, and secondly, that an award is presumed to be signed on the date when it's shown on its face to have been signed. Those are rules of law which don't require any kind of factual investigation whatsoever, quite the contrary. And so...
But a presumption can be rebutted, presumably.
The presumption
That's
can be
an
rebutted.
evidential matter, yeah.
Can be indeed rebutted. But of course, this is not a point that we have just raised. This is a point, I know this obviously takes me back to my primary point, which is that this point was before the Supreme Court, but certainly my learned friend, who in fact was acting for his client already at that stage, had notice of this point and could have rebutted at that stage. So this is a point, first of all, which we say is given the lack of any evidence, it is indeed a purely legal point, and therefore that we fit within the flashbird principle, which has been referred to by my learned friend at paragraph 32 of his written case.
Does it make any difference that you've got permission to appeal on grounds which include this ground?
I'm so sorry, does it make
any difference that you've got leave to appeal on grounds which include this ground, or is it open to him to make the objection irrespective of that?
We would indeed, this is indeed the point I was just about to make, which is that we'd say that there is indeed no injustice, because this is a point that has been known indeed by my learned friend and his client for some time. And of course the injustice point is a criterion that one finds in rules, which is another of the board's judgments, which has been referred to by the respondent at paragraph 32 of its written case. We would indeed submit that this point was made clearly in our leave application on the 27th of January 2022. One finds that at page 319 of the electronic bundle. I don't ask you to turn it up. And again in our notice of appeal on the 25th of July 2022, and the reference there is page 368 of the electronic bundle. So indeed, my lord, that's a long-winded way, I think, of saying what your lordship has just said, which is that this point was made some time ago. My learned friend and his client have had full notice of it since at least the 27th of January 2022, and therefore have had well over a year to think about it. But of course, we would ask your lordships not to lose sight of the fact that our primary argument in this respect is that this so-called new argument isn't a new argument at all. It was one that was made by the co-respondent, the arbitrator, before the Mauritius Supreme Court, and so it has in fact been argued or placed before at least the Mauritian Supreme Court. Now, my lords, turning, if I may, to the substantive aspect of the primary point that I'm addressing your lordships on. As you know, we argue that the arbitrator rendered his award on the 31st of December 2018, whereas my learned friend argues that the arbitrator rendered it on the 3rd of January 2019. Our position, my lords, is based on the French law principles that, first of all, an award is rendered on the date when it's signed, and secondly, that an award is presumed to be signed on the date that is indicated on the face of the award, in this case, 31st of December 2018, as can be seen from page 101, that's the signature page of the award, page 101 of the electronic bundle. My lords, these two rules are clearly stated in the French commentaries that we've relied upon, and in respect of which, as you know, there are translations. These, again, are translations and not summaries. And if I could ask your lordships to turn to those. And starting with page 1, your lordships will find, first of all, an article by, or a comment by a well-known arbitration practitioner called Bertrand Moreau. And at the bottom of the page, you will find paragraph 252 of his book, in the second sentence, the date appearing on the award must be deemed to be authentic. So this is the second of the two rules that I just explained that we rely upon. And then if your lordships would turn to, over a couple of pages, to page 3. This is, and you see that at page 2, this is from a leading textbook on arbitration, or practitioner's book on French arbitration law by Professor Seralini and Jérôme Ortscheid. And at page 3, in the middle of paragraph 325, your lordships will see the award is valid if it has been rendered before the dies ad quem of the term of the arbitration, even if it was notified only after.
Sorry, where were you reading from?
That's in the middle of paragraph 325, 1, 2, 3, 4, 5, 6.
Okay.
11 lines down. It's the sentence starts first in support of arbitration. It is admitted that the award is valid if it has been rendered before the dies ad quem of the term of the arbitration, even if it was notified only after. And then a couple of lines down, after the references, the citations, it says, it is sufficient that the award has been signed before. And so this, my lords, is the first of the two rules that I submitted to your lordships. And then turning on to page 6 of the translations, you'll find an excerpt from a work by Professor Éric Loquin. And in the second sentence of the first paragraph, your lordships will find the words, when an award bears a date, that date is recognized as authentic until a court decides that it is a forgery. So that is, again, the second rule. And in the next paragraph of this same work, the same excerpt, you will find that it says, case law has held that in principle the date of the signature indicates the moment when the award is rendered. And so that is the first rule. In the next paragraph, Professor Loquin refers to the 2017 judgment of the Cour de Cassation, which both sides have referred to and relied upon, and which I'll be turning to in a moment, and that is, just to explain to your lordships, that is the case that is being referred to in that third paragraph of this excerpt. Then at page 7, the next page, your lordships will find a comment by Professor Charles Jarosson. It's a comment on the judgment of the Paris Court of Appeal of the 30th of May 2006. And on page 7, Professor Jarosson provides 3 what he describes as aphorisms, which sound rather punchier in French than in the English translation, but the first of which is, and I quote, a sentence, in other words, an award, will be validly rendered if it's signed in a timely manner. The date of the award is not the date of posting. So that, again, is the first of the two rules that I submitted to your lordships. And then in the next paragraph, halfway down, this is the paragraph starting with, in bold, what does rendering an award mean? Halfway down, you'll find the words, rendering an award within the term of the arbitration agreement means having produced it through deliberation, having drafted and signed it within that time period. It is only that which must have been done at the time when the arbitration agreement expires. So that, again, is the first of the two rules. And that, I think, takes me to the end of these translations. And what I perhaps should have explained to your lordships, or submitted to your lordships earlier on, is the fact that both sides agree that French jurisprudence is relevant as a source of guidance in respect of Mauritian domestic arbitration law. You'll find that in the respondent's written case at paragraph 18 on page 425 of the electronic bundle. And this, my lords, is because Mauritian domestic arbitration law is based on the French Code de procédure civile, as amended by a decree of 1980, replaced in France in 2011, but with no relevant differences for our purposes. I should point out that well, first of all, we have explained this at paragraph 7.4 of our written case, which is at page 395 of the electronic bundle. And I should correct one thing, which actually I think has no consequences at all, but just so that we are absolutely accurate. We had said that, and I quote, minor amendments were brought in France in the 1980 regulation on the 12th of May 1981. In fact, the 1981 amendments had to do with international arbitration rather than domestic arbitration. And as I said a moment ago, I don't think that this makes any difference whatsoever to anything else that we have said in the submissions. So what is important is that the Mauritian domestic arbitration, obviously international arbitration, as your lordships already know, is based on the model law, but domestic arbitration law in Mauritius is based on French arbitration law as it was introduced into French law in 1980 by a decree in France.
Sorry, can you just give me that reference again, where you're in effect correcting perhaps what you said?
Absolutely, thank you, my lord. It's at paragraph 7.4 of our written case, which is at page 395 of the written bundle.
Yes, thank you very much.
Do we just delete that sentence, do we?
Yes, I'm sorry, I'm just putting up, but yes, indeed, that could be just simply be deleted. Absolutely. My lords, coming back to our case, respondent has contested the existence of the rule that an award is presumed to have been signed on the date indicated on the award. And turning to paragraph 24 of its written case, which is at page 427 of the electronic bundle, you will see there that learned friend relies upon what's described as the 2017 CC case. That's the one I mentioned a moment ago. A judgment of the Cour de Cassation of the 4th of May 2017. And what respondent says there in paragraph 24 is that, and I quote, this provides that the arbitral award is rendered when it's communicated to the parties, its content being acquired from that moment, and that the date of presentation of the award to the parties alone must be taken into account to determine whether the award was rendered within the arbitration period, regardless of its effective date of writing. My lords, with the greatest of respect, that is simply wrong. And I'll ask you to turn to page 4 of the document, not the document we've just been looking at, but the other document recently handed up, which is the agreed summaries of the case law.
The point that the respondent makes in the written case, correct me if this is wrong, was the argument produced on behalf of the losing party in the Cour de Cassation. It says it's the moyen annexe au présent arrêt, and it's produced by various people on behalf of the company Route de Magny. It's not the judgment of the court itself, as far as I can understand.
Your Lordship is absolutely correct. It is indeed, and I see Mr. Granet is more of a French lawyer than I am, nodding his head vigorously. It is indeed, the argument is something which comes from the moyen of the case, the arguments made by, indeed, the losing party, and is no part of the judgment itself.
The judgment is what precedes par ses motifs. That's the reason the court gives for deciding as it did.
Absolutely. That's absolutely correct. And a very brief, and if I may, I was going to take your Lordships to this case, but I see that you've already looked at it carefully. But if I may, and what I was proposing to do was take the English version, but if you prefer me to take to the original version, I can do that. But perhaps starting with the English version, then we can always cross-refer to the French version. You'll find at page 8 of the summary, the agreed summary of the French cases. No, I'm so sorry, that's not page 8, it's page 4. I was looking at the wrong case.
It's page 5, I think, isn't it? This case?
Well, on my version, and maybe it's the effect of having turned it into a PDF, but on mine it's 4. It's case number 5, indeed.
Yeah.
Sorry, case number 5 on page 4, indeed. Page 5? Okay, I'm sorry, I think I have different numbering from yours, but in any case, it is the one which is number 5, Cour de Cassation, 4th of May, 2017.
Yes, thank you.
Page 5 on mine.
Yeah.
And just to remind your Lordship, this is not a summary. Sorry, this is not a translation. This is a summary, and you'll see that in that case, the deadline for the award was the 10th of September 2010. You'll also see on paragraph 5.4 that the first page of the award indicated that it had been rendered on the 10th of September 2010, so within the deadline. But the signature page indicated the 13th of September 2010. The Court of Appeal annulled the award on the basis that it had been rendered after the expiry of the arbitration agreement, because it found that the award had been signed and therefore rendered on the 13th of September 2010, which was, of course, after the deadline. The Cour de Cassation rejected the appeal against the Cour d'Appel, the Court of Appeal's judgment, on the same grounds and without developing much further than what had been said by the Court of Appeal. Nothing, my lords, in that judgment says that an arbitral award is rendered when it is communicated to the parties. To the contrary, it says that an arbitral award is rendered when it is signed. And that, again, one finds at paragraph 5.8. This is in the summary of the Cour de Cassation's judgment. It says the award, which was dated the day it was signed by the sole arbitrator, was rendered after the arbitration agreement had expired. The award, which was dated the day it was signed by the sole arbitrator. It would indeed, as my lord has correctly indicated, seem that what has happened is that the respondent has based its submissions, as did, in fact, the Mauritian Supreme Court, on the moyen, in other words, the arguments made by the losing party in that case, and which were indeed annexed in the usual way at the bottom of the judgment, instead of basing their submissions on the judgment itself. And let me say that this is a mistake very easily made. Judgments of the French Cour de Cassation until 2019, when their practice changed, were highly confusing and very difficult to read. As I said, now the practice has changed and they've become more transparent in the way that the judgments are drafted. And therefore, my lords, we would submit that the respondent and the Mauritian Supreme Court simply got it wrong when they said that an arbitral award is rendered when it's communicated to the parties. And they did so because they have misread the 2017 judgment of the Cour de Cassation. And we would submit that the opposite is in fact the case, that under Mauritian domestic arbitration law, an award is rendered on the date when it is signed, which is of course consistent with modern arbitration principles. And here I come to the second rule, which I've submitted to your lordships. As I sought to explain above, an award is presumed to be signed on the date when it is, an award is presumed to be signed on the date when it's said on its face to be signed. This is, as I mentioned before, the second rule. And of course, in this case, my lords, the award was said on its face to have been signed on the 31st of December 2018, so within the deadline. To rebut that presumption, and my lord mentioned before that, of course, this could have been rebutted, but to rebut that presumption would have required respondent to have brought evidence that the arbitrator had actually forged the award. And I use that word because indeed that is the wording that was used by Professor Lequin in his commentary, which I took your lordships to a moment ago.
But didn't the Supreme Court find that it was signed on the 3rd of January?
The Supreme Court found that it had been delivered on
Signed and delivered, it says, page 300.
I'm so sorry. The Supreme Court found that it had been signed, but was incorrect in doing so because there was no evidence to rebut the presumption. No evidence had been put forward to rebut that presumption. And the Supreme Court certainly did not find, my lord, that the arbitrator had forged the award by putting the incorrect date on it.
Well, the Supreme Court said there was no evidence that the award was signed on the 31st, and I think you would say that's the wrong way round to look at it.
Exactly.
It should be presumed to be signed, to have been signed on the 31st, unless there is evidence to the contrary.
I know that is exactly our position. Absolutely. And we would also submit that there is in fact no evidence to rebut or to have rebutted the presumption. What there is merely some speculation by respondent. And for that, I'd ask your lordships to turn to paragraph 37 of their written case at page 432 of the electronic bundle. And there you'll see the points that have been made, which are at paragraph 37. And they say that the date of the award was typed rather than handwritten. They say also that the email of the 3rd of January 2019 said that the signed version of the award, and I quote, is now ready and you may collect with me. Well, my lords, we could speculate in a similar way. We could speculate also that it wouldn't have taken the arbitrator very long to make the changes that are shown at paragraphs 15 to 17 of the respondent's written statement, which you'll find at pages 433 to 435 of the electronic bundle. And very helpfully, my learned friend has there identified the changes that were made between the draft award of the that was sent to the parties on the 31st of December and the signed version that was subsequently sent. And your lordships will see that they're really not terribly significant changes, and they're certainly not ones that would have taken very long for the arbitrator to have made. We know, my lords, that the meeting between the arbitrator and the parties started at 1:10 p.m. That's page 71 of the electronic bundle. So presumably it would have finished well before 2 o'clock. And an experienced judge and arbitrator, such as the one in this case, could easily have made those changes we would submit and sign the award by the end of the day.
Well, then in that case, why wasn't it sent by the end of the day?
Well, my lord, it may have been that he simply preferred to have the award communicated via his secretary. Wouldn't be terribly surprising. And it may well be that she had gone home by then. It was the 31st of December. I understand, but I mean, this is totally speculation, that on the 31st of December in Mauritius, people tend to leave the office perhaps earlier than usual. But again, my lord, this is all speculation. I'm not at all, certainly far from giving any kind of evidence in this. I'm merely saying that this is the kind of speculation that we could also entertain. But it is just speculation. There's absolutely no evidence. And that is why, as my lord mentioned, we rely upon the presumption at the end of the day. And we submit that the Mauritian Supreme Court indeed got it the wrong way round by requiring evidence to be provided rather than by...
But that particular point wasn't raised before the Supreme Court, was it? The presumption?
The presumption, I believe, was in fact in... Well, it wasn't... Let me take your lordships to the actual part of the co-respondent's written submissions. It's a paragraph 26 on page 195 of the electronic bundle. And what the arbitrator said, the co-respondent said, was the last page of the award shows that the award was signed on the 31st of December 2018. The award was therefore made within the mandate of the arbitrator. Indeed, no reference was made specifically to the presumption having to be made. That is absolutely correct. But I believe, and perhaps I could come back to this later, but I believe that commentary, that doctrine, was provided by counsel for the co-respondent at that hearing in order to explain this point. But I don't have that reference at my fingertips right now. My lords, what at the end of the day respondent is asking you to do is to find that the arbitrator, who was at the time still a judge of the Mauritian Supreme Court himself, misled the parties and the Mauritian Supreme Court when he, first of all, dated the award the 31st of December 2018, as you see from page 101 of the electronic bundle, and again when he allowed his counsel in the annulment proceedings to say, at this paragraph 26 that we've just looked at of his written submissions, that, and I quote, the last page of the award shows that the award was signed on the 31st of December 2018. And also we would submit that there is simply no reason for you to make that finding. There is no evidence whatsoever on which to do so. And also, unless you have any further questions for me, those are my submissions, and I propose to hand over to Ms. Julien on the alternative ground.
Thank you very much.
Yes, my lords, I'm going to be dealing with grounds H and E together. Ground H and E only have to be considered by the board in the alternative to the primary case, as has been set out by my learned friend. Grounds H provides as follows. In any event, the learned judge erred in not addressing their mind to the fact that the respondent had, on 31st December 2018, stated that it had no objection to the edited version of the award being provided later on, which statement amounted to an unequivocal waiver, so that such objection could no longer be properly be relied on by the respondent. Ground E, the learned judges failed to address their mind to the issue that the arbitrator's final decision had already been made and that the essential parts of his award were read to the parties on 31st December 2018. These two grounds are covered by what the respondent has referred to as the third and fourth proposition in its written case. The third proposition is set out at paragraph 20C, page 4 to 8 of the bundle, 4 to 6, sorry, 4 to 6 of the bundle. So the third proposition is agreed with by the appellant, and it is further developed at paragraph 26 and 27 of the written case of the respondent, which are at page 4 to 8 and 4 to 9, and they are also agreed. I propose to briefly go through these. Paragraph 20C, an arbitral award shall be delivered within the time limit provided in the arbitral agreement, failing which the arbitral award would be tainted with nullity on the basis that the arbitration has failed to comply with its mandate. So we agree with that proposition. And if we move on to paragraph 26, which particularizes the third proposition, the first point at subparagraph A provides Article 1027(3), subparagraph 3 of the Code provides that annulment of an award is available if the arbitrator has failed to comply with the time limit of his mandate. So that's what we've said. Procedural flaws that would have an incidence on an award, such as expiry of the arbitrator's mandate, falls under the purview of that article, and we agree with that. And then an award delivered after the expiry of the contractual periods results in annulment for non-compliance with the arbitrator's mandate. So now turning to the fourth...
Just before you leave that, is annulment inevitable if it's outside the... if it's delivered late?
If it's outside of time, unless, well, if it's outside of time, it's because we haven't proved that we have been able to extend the mandate. So then we fall back on waiver.
No, but assuming it is out of time.
Yes, it is out of time. If it is out of time, it is
necessarily it is a nullity. There's no discretion in relation to that.
No, not in the Mauritius. But the fallback position is waiver.
No, I understand.
So in relation to the fourth proposition, which is at paragraph 20D, the fourth proposition provides the mandate of the arbitrator expired on 31st December and was not extended either expressly or tacitly. So we disagree with that, and I will come to that. The fourth proposition is particularized at paragraph 27 and 28. And paragraph 28A is not disputed. An extension may be express or tacit, subject to certain conditions. Paragraph 28B provides when a party contests that it has tacitly given its consent to the extension, the proof cannot be drawn from the observation made by the arbitrators in their award that they have obtained the consent of the parties. We disagree with that proposition to the extent that the statements made by the arbitrators in the course of the process is one type of evidence that the court and the board is allowed to have recourse to in determining the common intention of the parties or whether there was an agreement. And the respondent has provided no legal authority in support of that proposition, so we disagree with it. Paragraph 28C, a tacit extension will have to result from unequivocal positive acts showing the will of both parties to extend the duration of the arbitration. So the Appellant agrees with the principle as stated, and this is apparent from the case law that we have relied on, which provides for the principle. However, what we would say is that the French and Mauritius courts have applied this principle very liberally, as was stated by Seraglini in his commentary on domestic and international arbitration. And that commentary was quoted by counsel for the respondent in oral submission before the Supreme Court. And the quote was at page 195 of the electronic bundle. If I may just say a few lines about that commentary. It is note 329, and it says, given that the parties' agreement to extend the mandate of the arbitrators is not subject to any specific formality, it can be tacit and result from the circumstances of the case. Case law is particularly liberal on this point. So, and this is what I am referring to when there is an acknowledgement of the liberal way in which this principle.
Sorry, could you just where are you reading?
Sorry.
So
Can you tell me where you are?
Yeah, footnote. So at page 195, the counsel for the respondent has quoted footnote 329,
Sorry,
but
page 195 the
of the electronic bundle.
the main electronic bundle. Yeah.
This is the submissions of the arbitrator, is that right?
No, this is the oral submissions of the respondent. 195. But it is, the quote is in...
Well, perhaps I'm in the wrong bundle then. I was looking in the record, but you're perhaps looking in one of the other bundles. Is it the key documents bundle?
No, it's the main master set.
My 195, like my lord's, is also the arbitrator's written submissions.
Yeah.
Which includes the paragraph that we were taken to earlier about the award signed on the 31st.
Yes, I see. So I will double check that reference. This is probably not the correct reference. It's in the submissions, but I will provide the quote. But the footnote, the note that is referred to in there is actually in French, and it has been translated in our in the appellant's translation, the document that was filed recently, and it is at page 4.
I think I found what you were referring to. It's in the key documents bundle at page 195 for the Supreme Court. Transcript notes of proceedings.
Documents.
The
main bundle.
The main bundle.
Well, the one we've got in hard copy.
Well, can't be that. That only goes up to 162.
You don't have a 195.
Yeah, I don't.
All right, it's 206, MS page 206. Sorry.
Okay, sorry about that.
MS page 206 in the key documents. It's got a 195 also on the page.
Thank you.
No.
I think it's what you're referring to, because there is on the next page under note 329, prorogation tacitement consentie par les parties.
The mistake stems from the fact that the reference was the reference to the court record, so I apologize for that. So indeed, and the counsel for the respondent here quotes the extract of the commentary of Seraglini, and that extract is...
Sorry, you're just going a little bit too quickly for me.
Yes.
I've now got the document you're talking about, so we're on page 207 of the electronic file.
Yes, it starts...
What exactly are you reading? Where are you picking it up?
Yes, so it starts at the bottom of page 205.
205?
Yeah. And the last paragraph, where counsel for the respondent says he has put in, and he's referring to counsel for the correspondent, he has put in arbitrage commercial and referred and underlined the different points he wished to address the court. And then there is at page 37 of this particular extract which I read, droit de l'arbitrage. It is another of, c'est la doctrine which recapitulates obviously what they consider to be the law. And then there is a quote in French here, la prorogation expressément consentie. And that part, and all the part that is quoted there is translated in the translation of the appellant's translation of commentaries, and it is at page 4 of the translation document of the commentaries. And
Just one moment.
Yeah. And it's the note 3 to 9 of that document.
Thank you.
And here the author says that the court applied the principle of tacit consent to an extension very liberally, and there are a number of examples that are cited in there which explain that the French courts would readily take into account the conduct of the parties, including, for instance, non-objection of the parties to a certain course of action that they try to then come back on.
Is there any reference here to the words "a liberal approach will be taken"?
Yes. So it's the third line of note 329. Case law is particularly liberal on this.
Thank you very much.
But the intention must be unequivocal.
The conduct, the principle, the case law says that it has to be unequivocal, but in our submission, the courts, the manner in which the courts apply this principle is sufficiently liberal so as to allow for some flexibility in determining whether a conduct potentially has one or two potential meanings. So unequivocal, yes, but actually applied in a rather loose manner.
Well,
because the courts would, would want, in the right circumstances, to uphold an arbitration award when a party has conducted itself either out of bad faith or in a manner which is inconsistent with the argument that is subsequently raised to challenge the award.
This commentary suggests you can have an agreement even after the time limit's expired. Is that right?
No, admittedly, the cases that we have referred to are, all of these cases deal with the situation where there is an initial expiry date, and then there is a conduct of the parties post the expiry, for instance, participation in the proceedings, and non-objection of a party to that participation. So therefore, in these cases specifically, the conduct was post-expiry. So the courts were willing to accept that that conduct amounted to a tacit prorogation of the mandate. In the present case, the situation admittedly is slightly different because the conduct that we are looking at is a conduct that predates the initial expiry. However, maybe I'm going a little bit ahead of my arguments here because I will be dealing with these.
Well, the commentator seems to raise the point that my Lord Hamlin has raised, and that the commentator in that note 329 is questioning whether it's correct that after the expiry of the mandate it can be extended by agreement.
Further down, yeah.
Which line is that?
Well, I'm looking at, is it not instead a waiver? Technically, we can question the merits of a reasoning, look at the translation, which deduces from the conduct of the parties post-expiry of the term of the arbitration the acceptance of the parties to the extension of the term.
Yes.
Is it not instead a waiver of the right to rely on the expiry of the mandate?
I will come back to that, but on this particular point, the case law, the Mauritian cases, the Privy Council cases that we see on the point do not, unfortunately, I don't know if it's fortunately or unfortunately, do not make a very clear distinction between express judicial contract, implicit tacit prorogation, waiver, they tend to broad brush the issues, which is not necessarily very helpful to us trying to make the distinctions here. But I think it's because the idea behind those cases is that there is a conduct. Sometimes it can be conduct, sometimes it can be written statements, and all of that together, the courts will be ready to consider all those together to make a decision that is in equity, potentially the right one, taking into account good faith. But I'll come back to that if it's...
Can I just ask, it's a very general point, is arbitration law on this issue something that is peculiar, or are these concepts simply a reflection of the general law of contract?
Well, there would be a reflection of the law of contract, but in the specific context of procedural, let's say, procedural waiver or judicial contract. So it's contract, but dealt with from the perspective of a procedural issue. And sometimes, yes, maybe because it's not a question of substance, but of procedure, potentially the courts would deal with the principles of contract slightly differently. The cases don't really make that distinction, but generally it is contract-based. So if we are dealing with an issue of contract, it would be inspired by French law. However, the Mauritius courts may have developed certain principles in the context of procedure or procedural waiver, which gives a slightly, potentially, a slightly different touch to it. But there's a bit of overlap between procedure and substantive contract law here.
For my part, I'm struggling a little bit to pin down the submission you're making on paragraph 329.
Yes. So what I'm saying is that the word, and that maybe is to be tied with paragraph 28D, which is the fourth proposition,
yes,
where they say, well, there needs to be no room left for doubt as to whether the conduct that we are looking at, no room for doubt that that conduct means that there has been a tacit prorogation. So what they are saying is that our understanding of their position is that there is only one possible answer to that conduct. This is the point that I understand they're making. What we are saying is that by definition, when we're dealing with conduct, we are not necessarily always dealing with words. And in some instances, maybe there could be two potential solutions to the conduct, or two potential meaning to the conduct. So the court might be willing to accept that there has been a tacit prorogation, despite the fact that maybe there is not only one possibility or one explanation for the conduct.
And so what is the appropriate standard then? Is it as my Lord Burrows put you, a question of interpretation applying ordinary principles of contract law?
In determining whether there has been an extension, well, if we're dealing with conduct, then we are dealing with waiver. And so may I suggest that I come back to that because I've prepared these submissions in a manner which is slightly more structured than dealing with this in this context, because there will be more background to it, so it might be easier to deal with this. Okay, so I think I've dealt with paragraph 28D, so I'm going to move on to the first objection of the respondent, which is in relation to the tacit prorogation, which was not part of the appellant's argument below. So the point here of the respondent is not that it was a new point. The point here made is that it was not a point made by the appellant. Admittedly, this argument was not submitted on or dealt with by the appellant. However, the test is not, in terms of admitting a ground, the test is not whether a party has relied or submitted on a particular point. The test is whether that point was before the court. And I will go through the evidence that shows that it was clearly before the court. And the respondent has put forward no legal authority supporting the proposition that if a party has not argued a particular point, that it is precluded from then bringing an appeal on it. In my submission...
But you were just showing us a page of the proceedings, of the transcript, where this was being addressed in submissions, and the
Yes.
court was being referred to the written submission of the
Yes.
co-respondent. So it was actually being addressed in the oral argument.
It was being addressed in the oral arguments. Counsel for the appellant did not make any submission on this. However, it is...
Well, counsel for the respondent felt he needed to deal with it, if these are his submissions. I'm not sure whose they are. But can you help us whose submissions they are when on that page 206, where it was being, which you read out to us?
This is the respondent's submissions.
To the Supreme Court, in oral submission.
To the Supreme Court in reply.
Right. So he felt he had to deal with this point about tacit prorogation.
Yes.
He was addressing the court on it.
Yes, and that was raised by the correspondent in written submissions as well as in oral submissions, and I'll provide the references because I'm dealing with that at the very end. But the point here is that this objection is irrelevant, whose argument it was, so long as the appellant did not deny that position before the Supreme Court, and so long as it was made. The appellant has suffered prejudice as a result of the Supreme Court not upholding the argument of the correspondent to the effect that the mandate of the arbitrator had been extended, and as such, it is entitled to challenge the finding of the Supreme Court on the point.
Well, the Supreme Court didn't address this point.
The court, well,
in the judgment.
The court chose not to address this alternative case. It stopped at the question of signature. That was a choice of the court. And
well, it was a poor choice because either would be sufficient.
Yes, yes, but that cannot preclude the appellant from raising this point on appeal in our submission. And the respondent has not put forward any authority to support the argument that the admissibility of a ground of appeal is conditional upon the appellant having itself raised or argued the point below. The court is concerned about injustice, and if injustice results to the appellant from a finding made by the court on a point which the appellant did not actively submit on, it ought nonetheless be allowed to challenge it. I will now move on to the second objection, which is relating to the express judicial contract. So the argument of express judicial contract is said not to form part of the grounds of appeal and was never made an issue before the Supreme Court. I believe it would be helpful to first clarify what the position of the appellant is on the point, to then take the board to the relevant passages of the record that demonstrate that this point was before the board, although admittedly, not before the board, before the Supreme Court, although admittedly formulated in different words. Well, while there could be in principle differences between an express judicial contract and a tacite prorogation being an implied extension of the mandate, it is submitted that in the particular case at hand, there is in fact no difference as far as the facts are concerned and the evidence, and the argument of judicial contract, express judicial contract, is just formulating more or less the same arguments differently and presenting it slightly differently from a legal perspective. In the case of Dora, which I have referred to in our submission, the Supreme Court quoted Dalloz, explaining that a judicial contract comes into existence whenever the judge notes or records the agreement of the parties without the judge himself taking a decision. So there are discussions before the court and the parties, which are recorded in minutes or transcripts. And
can you just remind me which paragraph in your submission?
Submission, yes. This is paragraph 7.48 at page 408.
Thank you very much.
Okay. Okay. So we have set out in our written case at paragraph 3.8 to 3.13, page 383, the factual chronology on which the appellants rely to show that there has been an agreement of the parties to extend and/or a waiver. The agreement, the judicial contract, is evidenced in the minutes and the transcript of the meeting of 31st of December. So the terms of that judicial contract are as follows. There was a request made orally by counsel for the respondent to be provided with a copy of the unsigned award, and that request was accepted by the arbitrator and the appellant.
Sorry, are you reading from somewhere, or is this a...
No, these are just my notes.
Can you go a bit more slowly
Yeah,
then?
these are just my notes. So, I mean, chronologically speaking, there was first a request of the arbitrator to be allowed to read the introductory and operative parts of the award, which was accepted by the parties. Then there was a request made by counsel for the respondent, and I will read the exchange, to be provided with a draft copy of the award, and that was accepted. And then there was a request from the arbitrator that he be allowed to provide the signed award later on, and that was accepted. The relevant exchange is that...
That he be allowed to provide a copy of the signed award later?
That he'd be allowed to provide the signed award later. And the relevant exchange is at page 126 of the electronic bundle. And
Page 126.
126.
So this is not the official minute you're now relying on, which was the previous principle, the judicial contract. Is that right? This is a transcript.
This is a transcript. There were minutes.
I know, but we've got to keep this distinct, though, because you've made a submission that you can have a judicial contract based on the minute, as I understand it. And or are you saying the transcript forms part of that?
Well,
or is it just not evidence of what happened?
The transcript was not excluded in the Supreme Court in the end. So in my submission, it became part of the record. At this point in time, there was no exclusion of that particular evidence as being, ultimately there was no decision that it was not an appropriate record of what was happening, what was said in court.
No, I understand that. It's evidence of what was said in court.
Admittedly, it's not an official version.
No, but it's just what it says. It's a transcript. Yeah.
What do we make of the exchange between Mr. Domingue and Mr. Mamouji on our page 126, where Mr. Domingue says, well, issue it when it is edited, and Mr. Mamouji immediately says no.
Yes, this point is particularly important because the request to be provided with a draft copy came from the respondent, whereas the appellant's counsel was prepared to wait for the signed copy. And we don't know what would have happened if that course of action had been taken, but certainly what we know for sure is that the request to be provided with a draft copy actually came from the respondent. And that's very important because the irregularity, the alleged irregularity that the respondent attempts to rely on ultimately stems from a course of action that was taken by the respondent itself.
When the arbitrator is saying, OK, you need a copy, he means a copy of the draft that I've just read from. Is that right? And then Mr. Domingue says, is in effect saying, no, I don't need a copy of the draft. I'll wait for the final version.
Yes.
and then Mr. Mahmood is saying, no, well, he wants a copy of the draft, doesn't want to wait for the final version.
And what's important, of course, is after that, well, at this point in time, what's important is that at this point in time, the operative part of the award had been read to the parties, so the respondent was aware of the unfavourable award against it. I will now move on to the question of interpretation of those terms. Admittedly, the term "a copy will be provided," or "I will provide a copy later on," is ambiguous, as we have submitted in our written case. Hence, the court is entitled and ought to determine the common intention of the parties based on the writings, and the circumstances which we submit includes conduct, and I will come to that. The case of Gem Management versus Firefox is a Privy Council case 2019. It is at page 410, and it is referred to. It is referred to at paragraph 7.53 of our submissions of our written case, and it is at page 410. So this case speaks of ascertaining the common intention under Article 1156 of the Civil Code, bearing in mind the context in which the contract is drawn up, as well as the surrounding circumstances. So under Mauritius law, which is inspired from French law, the court are allowed to look at the common intention, and in doing so, they are allowed to take into account the surrounding circumstances. And it is our submission that here the surrounding circumstances allow the court to take into account conduct, for instance, what happened or what happened after the receipt of the draft award, or what the respondent did or did not do thereafter. And the court may also draw appropriate inferences to give effect to the common intention according to that case. In the present case, the board may draw adverse inferences from the circumstances in which the arbitrator was led to agree to provide the draft award. And the court ought to be allowed to draw inferences from the bad faith of the respondent and the fact that it was at his request that an unsigned copy was provided. The award...
Would you say that was a contract to which these principles of contractual interpretation apply?
So that here we are
something else.
Yes. So we are looking here we are looking at the principles of interpretation under contract law.
And they apply, do they, to both oral contracts and written contracts?
Yes, except that in French law, you would need to have a beginning of a writing, what we say. If we don't have a written contract as such signed, then we will rely on written communications. So you wouldn't have, French law does not recognize an oral contract without any written evidence that there was some sort of contract.
Because I'm just looking at this phrase, le contexte de l'acte, and there isn't an act here, is there?
It's article. Sorry, which act? L'act here is the...
It's the contract.
It's the act. The act here would be, yes, let me just check the wording. C'est 53. Just bear with me. Yes. Yes, but here, generally the rules would apply. Here we have an oral contract that is evidence in writing. So under French law, that would be a valid contract because there is some sort of evidence evidencing the contract. So here, in my submission, when we're talking about the act, it's not necessarily aimed at excluding the situation where you might not have a signed contract, but a contract is proved by written exchanges, for instance.
So the same principles apply?
Yes. So what is the case of the appellant on the common intention? It is stated at paragraph 7.555 of the written case, which is at page 411. The common intention of the parties was that the arbitrator could finalize and sign the signed award whenever he would be ready to do so, which could be prior to midnight or after, because admittedly later on was not a clear term. And the respondent waived its right to insist on the expiry date of the mandate of 31st December. And the mandate of the arbitrator was extended until such time as he was ready to sign and communicate the final side award. Not later, though, upon resuming work after the start of the new year. Accordingly, the mandate of the arbitrator was extended for a term expiring on the date when the signed award was going to be signed. So that was, according to the appellant, what the common intention was, which is, like in English law, it's an objective test. So it matters not, of course, that parties may have understood it as a matter of fact differently, but the reasonable interpretation to be given to the words are, as I have stated in that paragraph 755. Now,
So it's part of your submission that objectively this must not be later than upon resuming work after the start of the new year?
yes, this is the evidence of the appellant, but the party, well, the respondent disagrees, so we can't say that it's, as a matter of fact, it is presented as being agreed, but it is, the common intention is that, well, the appellant has given evidence that the understanding of the appellant was that it would be upon resuming work. But more objectively, the point could be interpreted in a, I would say, in a slightly more loose manner. What was clear, it was not clear when the award was going to be rendered, but what was clear is that the parties agreed that the arbitrator would be given the time to complete the formality that was required. It wasn't really clear whether it was before the 31st, and the parties have provided contrary evidence on that. But the reasonable way of interpreting those words, bearing in mind, and I will come to that, bearing in mind good faith and equity, would be to agree that the arbitrator would be given the time required after 31st to complete the formalities, and not later that upon resuming work.
But why isn't it objectively within a reasonable time?
Well, the evidence is that all the parties were under the understanding, or at least the appellant understood it to be, because there was urgency that, I mean, that is part of the affidavit of the appellant, that as soon as possible, I suppose because there could have been urgency and the parties were pressed with time. I mean, reasonable time would be a different way of putting it, but this is how the appellant viewed it. But in the alternative, it could be indeed reasonable time.
It would be a reasonable time, on your submission as I understand it, to complete any editing work and the formality of signing it and to deliver it to the parties.
Yes, as soon as possible.
Well, I mean, if the substance of it has been already given to the parties, a reasonable time involving mere editing would be when? That same day, or
there was
2 or 3 days later, or the start of the new year?
there was, I mean, 1st and 2nd of January were public holidays, so the 3rd of January was the first business day after the public holiday. So that was, in our submission, certainly reasonable. And also, I ought to draw the board's attention that it was agreed, and I say so in my written case, or in our written case, it was agreed between the parties, there was some sort of formality in the process, and it was agreed between the parties that they would be present when the award would be delivered, which is why they were called on the 31st of December. So it is possible, there is no evidence as to what was happening, what happened in the mind of the arbitrator, but it is possible as well that that formality was expected to be potentially repeated again when the signed award is produced. I mean, it's a possibility.
What do you say is the significance of the Respondent's Council asking for a copy of the draft award? Do you say that is a acknowledgement that there may be some delay and that the final award might not necessarily be ready that day, which is why he wants a copy now of the draft award, or what is the significance?
No, I mean, the only significance that we say this request has is really the bad faith. Well,
say bad faith, but why is it bad faith? Or I mean, what is the implication of asking for the? It comes back to the same thing. What is the implication of asking for a copy of the award? What do you say?
Well, we don't say that award. We have not insisted on the case that was on the position that was put before the Supreme Court that award was a binding award, that we have not challenged the Supreme Court's finding on this. So we cannot say the reason why the respondent was asking for this, potentially because they just wanted to see what was said in there. But certainly the point that we make about it is by asking for it, and we have to bear in mind that everything that follows afterwards and the challenge on the potential irregularity stems from the fact that there was a draft award requested, because potentially there would have been a different course of action if that draft award had not been requested. Potentially there would have been a discussion about timing of the signing of the award or the manner in which it would be delivered. We can't speculate on this.
So what is the implication? That they're happy with, they're not dispensing with the need for a final award, so presumably is not the implication that they are content not necessarily to get it straight away?
Well, that is, yes, I mean, that is a point that we make when we are trying to interpret the work later on.
Otherwise, if it's not that, I can't see why it helps you.
Yes, I mean, this is the point that we make when we say that later on meant later on after resuming work or within a reasonable time. So, yes.
So this shows that it's contemplated that later on didn't necessarily mean that day. It could be going into a later day.
Yes.
And that the exchange about needing a copy is evidence of a mutual understanding to that effect.
Yes, and we have set this proposition quite clearly in our written submission on the point when we're dealing with later on. So now I'm going to address the point made at paragraph 7.56 of our written case. And in there we say that here we have looked at common intention, but we can reach the same outcome by having recourse to Article 1135 of the Civil Code, which allows the court to infer into an agreement an obligation which ought to be imposed on the contracting parties for equitable reasons, bearing in mind the nature of the contract. And an example of that is the case of the Central Water Authority, which I have referred to. And in this case, a strict application of the law would have required a letter before action to be sent for the creditor to be able to claim interest, and the letter before action had not been sent. Nonetheless, the court held that the arbitrator did have the power to award interest even absent such letter, as the role of the arbitrator included the application of equity under Article 1135. So here, the reference in the Civil Code to equity actually allows the court to imply a term into the contract. It is about implying a term in the contract. If the circumstances...
Into what contract?
Well, here we are talking about the judicial contract to extend.
So you're assuming there is a judicial contract?
Yeah, we assume there is a judicial contract. In the alternative, if there's no express judicial contract, we have an implied extension of the time. And I ought to clarify that together with the extension, there must necessarily clearly be also an agreement that the respondent would not insist on the initial deadline of 31st.
So the agreement that we're being asked to imply a term into is not the original arbitration agreement, it's the agreement which you say is recorded in the minutes of the meeting
Yes.
of the 31st.
It's the judicial contract that extends the mandate of the arbitrator, and also that agrees, or pursuant to which the respondent agrees not to insist on the 31st of December deadline. And the case of Casimir versus Gachet, which is a Mauritius case, an old case, is also referred to in there at paragraph 757. I'm not going to touch on it, but this is just an example of where the courts were willing to take into account considerations of equity and good faith in interpreting an ambiguous term. So at paragraph 7.59, I conclude by saying that the conduct of Alphamix and the arbitrator after the conclusion of the judicial contract demonstrate that they both understood and relied on there being no procedural irregularity with receiving the signed award after 31st December. Similarly, counsel for the district council did not object to the signed award being provided later on, and he also failed to seek clarification as to the meaning of these words when he accepted the proposal of the arbitrator, and again, after having received the email of the secretary in which the latter wished the parties a Happy New Year. The last time we hear of the arbitrator is through the secretary in the email at 1356, and in this email, the secretary says Happy New Year. So presumably, and bearing in mind that the communications had been done through the secretary, when the secretary says Happy New Year, to the extent there was a potential doubt in relation to the timing of the signing or the communication of the award, it is our submission that at this point in time, good faith would have required the respondent to seek clarification. And they did not do so. Why? Because they knew that the award was not favorable to them, which is why they waited until midnight. But the duty of good faith, be it as a substantive duty or in procedural matters, the duty of good faith requires some active steps being taken by parties, and not simply to wait and allow time to expire, to then subsequently come to the court and say, oh, actually, by the way, the mandate has expired.
Can I just ask a factual question about what you're saying in 759? The transcript that we've got, I think, is not a complete transcript because the phone wasn't switched on at the beginning of the meeting.
Yes, my understanding is that the beginning of the conversation was not recorded.
The phrase later on does not appear in the transcript which we have got. It does appear in the secretary's minute of the meeting. When did
Which phrase exactly are we referring to?
Later on.
An edited version will be provided later on.
Yes.
So, is there any evidence that that phrase was used in the meeting itself? And if not, when was the minute actually communicated to the parties so as to give them an opportunity to clarify or object, as you say they should have done?
My understanding that before the Supreme Court, the minutes of the meeting were, if you can check, were annexed to the affidavit provided by the appellant in response to the application. So it was put in quite early on, and I believe there was an objection made to it, but the objection as to the admissibility of that document was not successful.
But your point, I think, is that there should have been an objection or a request for clarification by the end of the 31st of December 2018. But if that phrase had not been communicated to the parties before then, there would not have been any obvious reason to clarify anything, would there?
I understand. Well, then the argument is that we have the email of the secretary which says Happy New Year, and we would say that the argument is along the same line.
But don't you also say that the minute is a record of what was said, and it's the best evidence there is of what was said, and so we take it that there was a discussion before the tape was switched on along the lines that it will be provided later on.
Yes.
And that's the best evidence of how it was put, ambiguous as that may be, which is then, you say, subsequently clarified. But, I mean, the respondent didn't have to wait to know what was said, because we're assuming that is what was said.
Yes, I mean, this is what was said, and clearly if he thought, or if the respondent thought that there was uncertainty or a particular potential irregularity, the respondent ought to have clarified, ought to have acted. It is our submission.
So on the assumption it was said, then your submission is it
and the assumption that it was said,
there should have been a request for clarification.
Yes.
But there's no dispute that the minute was an accurate record.
There's no dispute on this point.
The chronology is agreed, isn't it?
Yes.
Yes. Okay. So, okay, I'm now going to move on to. So just one last point here. Before the Supreme Court, I don't have the reference, but we will provide it after lunch. Before the Supreme Court, counsel for the respondent said that there was a pattern in relation to the extensions of time of the arbitration agreement, of it being in writing. It is correct to say that the last two extensions were in writing, and I have provided the reference for that in the written case. However, it is not correct to say that that represented the dominant pattern, because in fact, it is apparent that in about several instances, it is apparent from the record that the time was extended orally, so by judicial contract, before the court, before the arbitrator. I'm just looking for the reference, if I may just be given 1 minute. No, it's not that. Here it is. Okay, so we've got at page 59 of the electronic bundle, we've got the minutes of a meeting that took place on 7th of June 2016. And it is stated, at this stage, the matter is adjourned to Wednesday, 17th of August, 2016, for mention, respondent to take a stand on the ruling delivered and parties to sort out this issue of topping up of arbitral fees. The arbitrator's mandate is accordingly extended up to the end of November 2016. So this pattern is actually repeated several times. The minutes of a meeting of 30th of July 2016 at page 64 where it is stated at this stage, so that's the last paragraph, at this stage both parties move that the arbitral agreement be renewed for a further period of 2 months. And then at page 63 and 64, hearing, so we've got the minutes.
That's what we're looking at, page 64.
Sorry, just bear with me. So, sorry, at page 63, 64, we have, so that was the beginning of the discussion, and then at page 64, it is stated, Mr. Mohamed, there is a joint motion at the very top, there is a joint motion to renew your mandate as arbitrator until the end of November. So, my lord, I'm a bit pressed with time, so I will just make the references to the other statements made before the arbitrator, which extended the time, and these are at page 65, the hearing of the 8th of September 2017, where there was an extension of the contract, and another one for the hearing of the 6th of October 2017 at page 67. So now moving on to tacite prorogation. Tacite prorogation was heavily discussed and dealt with below. Our submission on tacite prorogation is, in fact, the evidence and the facts that we rely on for the judicial contract are exactly the same. However, the legal principle that would lead to the same outcome is presented slightly differently. So tacite prorogation would be an implied agreement by conduct, so it would allow the court to look at conduct overall without necessarily being tied to starting with written instruments in terms of a contract. So we have stated in paragraph 763 that the arguments we make on the facts are relied on as well for the tacite prorogation, which is an alternative case. And I have already explained that the Mauritius and Privy Council cases do make reference to these concepts, judicial contract, tacite prorogation, and waiver in a rather loose manner. So as regards waiver, the definition was provided in the case of Rameshwar, which is at paragraph 764, I believe, of our submission.
Yes.
And the principle of waiver is that if one party by his conduct leads another to believe that the strict rights arising under the contract will not be insisted upon, intending that the other should act on that belief, and he does act on it, then the first party will not afterwards be allowed to insist on the strict legal rights. So this is just waiver. And I won't go through the cases which we have referred to, but there are several cases referred to in our submissions at paragraph 7.65, 7.66, which gives examples of that principle being applied. We also rely on French authorities, and I won't take the board now to those. The only point I will make is that we accept that those authorities deal with conduct which postdates the expiry of the term. I have already said that before. Nonetheless, and the conduct we are looking at here predates the expiry, nonetheless, these authorities show the high threshold that is imposed on parties to the arbitral process in terms of their procedural conduct, and the expectation that they would act in good faith and promptly in raising any issue which they could potentially be relying on subsequently to seek to annul the award. This is all the more important here in arbitration, where the parties have given up their right to appeal on the merits and expect finality with this process. In the present case, the respondent failed to act in accordance with such duties by remaining willingly silent on a point which it knew very well could be subsequently used to seek to challenge the award. The conclusion on these grounds is stated at paragraph 7.72 of our written case, and I won't repeat it. Just to provide references to the place where the point about tacite prorogation was dealt with below. So the correspondent, in its written submissions, which are at paragraph 31 and 34 of the written submissions of the correspondence, page 196, it may be useful to turn to that page because this is an important one. So at page 196, paragraph 31, so 31 to 34 set out some factual backgrounds, and then 35 says, in the circumstances and on the uncontroverted evidence on record and the unequivocal conduct of the parties, it is open for this court to find that there has been a tacite prorogation, with the resulting effect that the physical communication of the award was well within the mandate. So this point talks about tacite prorogation and the extension to 3rd of January. And then the Respondents' Council has addressed the argument of tacit extension, and we have already gone through this evidence. And okay, so now I'm going to provide the references that the appellant relies on to demonstrate that the point about judicial contracts. So I have finished now on explaining that we have a primary case on express judicial contract. In the alternative, we have tacit prorogation, but as a matter of fact, we don't believe there is much difference between the two because they are based on the same facts.
Can I just ask, where do we find the concept of tacit prorogation actually referred to?
In the court below?
No, sorry, in the authorities or commentaries. Where is this concept coming from?
Well, it's the French commentaries. It's the French commentaries. In our submissions, we have provided all the references, and everything is in there, and we don't believe that the respondent actually dispute that tacit prorogation is an accepted way of agreeing to extend the mandate, bearing in mind that extension of the mandate is provided for in Article 1015.
So it's in the commentaries?
Yes.
Thank you very much.
And it's Article 1015, which says that an arbitration agreement may be extended either by agreement, and then the doctrine, the commentaries, come and clarify that agreement can be either express or tacit.
I think you also.
It's in the case law. It's in the case law. It's in the case law. The commentaries, in fact, refer to the case law. So we have it covered both in the case law and in the commentaries. The references are provided in the written case, but we are happy to provide them again maybe later. So just to finish, I have finished on this. Why was it necessary to add not to add, but to put forward judicial contract? We don't actually believe that there's a big difference between the two. However, there are Mauritian cases which expressly address the issue in terms of a judicial contract. And we think that in this particular case, because there were discussions before the arbitrator, that is a case where we could say that there was in fact a judicial contract. But the facts are the same. The legal principle leading to the outcome is different. So why do we say that judicial contract? So the objection, just to finish, the objection of the respondent is that judicial contract was not part of our ground, and it is not dealt with below. So it is not worded as being a ground on its own, and because it is covered in our submission, it is covered by ground H, which provides that by conduct the respondent unequivocally waived the objection to the expiry. So how did he actually waive this? It's because there was an agreement to extend, and that agreement to extend necessarily also included an agreement to waive the entitlement to rely on the expiry.
Well, isn't the reason why one's inclined to use a phrase such as waiver, that the agreement may not have been an agreement as such to extend the period of the mandate, but it may have been an agreement that no objection would be taken if the signed award was provided after the end of the mandate. And that was what was agreed. Yeah,
the agreement, and that is apparent from the paragraph where we talk about the common intention and what the common intention was. The agreement is twofold. The agreement is an agreement to extend, but separately it is an agreement not to rely on a potential irregularity arising out of having been provided with the copy and allowing the signed award to be provided later. So it's two separate agreements, and they are separate. And it is our submission that the second part of that agreement could stand, even though potentially the first agreement to extend, or even if the agreement to extend the mandate does not stand, this does not necessarily mean that the agreement on waiver would fall away. And then, of course, we have here the agreement, we have also the waiver itself, the unilateral waiver, which is a slightly different point. The unilateral waiver would be the court looking simply at the conduct of the respondent and not necessarily needing to find an agreement from the appellant and the arbitrator. However, if the board finds that the conduct of the respondent showed that there was a waiver, then it is difficult to see how the board could conclude that the appellant did not agree to that waiver or that the arbitrator did not agree to that waiver. The board would not presume an intention from the arbitrator that would result in his award being invalid. And the appellant has said themselves that they agreed that he would not be entitled to reliance. So the point I'm making here is that in principle, unilateral waiver and agreement to waive would be slightly different because one requires the agreement and the other not. But as a matter of fact here, if the board finds that there is a waiver on the part of respondent, it must necessarily follow that all the parties agreed to that.
But if it's a waiver, according to the principles you've stated at 7.64, there has to be reliance on it. And
yes, there has been reliance on it.
Right.
There has been reliance on it because the arbitrator did not communicate the award on the same day.
That's the reliance you rely on.
Yes, that's reliance. And also reliance on the part of the appellant, who did not take any step following the exchange, because clearly the appellant assumed that the exchange meant that they would not be insisting on the expiry. And where so the judicial contract is covered by Ground Edge, but then where was it dealt with before the Supreme Court? So I've got a couple of references here. Counsel for the correspondence submitted in oral submission that an agreement to extend could be express or tacit. This is at page 197, so that this
Page 197.
197
of
the electronic bundle, and that is simply the statement that an agreement can be express or tacit. So judicial contract is express, or we have pleaded it as being an express contract here. So that covers at least in one instance. And then also, counsel for the respondent himself made reference to the note that we have looked at, which is note 329 of the commentary of Seraglini. And this is at page 4 of the translation that we have looked at earlier on. And this commentary provides that the extension of the term can also result from the acts of a person who has been vested with a mandate to represent a party in court. When it is a lawyer, it was held that it was not necessary that he needs a special authority to accept an extension of time in the name of the parties. This was actually referred to by the respondent of its own initiative. And that clearly here, the reason why this was contemplated or dealt with, it's because the circumstances of the conclusion of the contract here were made through statements made by the lawyers. So, and nearly there. And the appellant in its first affidavit at page 109 also makes reference as to an agreement in the following words. The correspondent pointedly undertook to the parties and their legal advisors that on account of his state of health, they would later be provided with an edited and formatted copy of his award handed down on 31st December, given that he was on that day visibly suffering from a bad flu, and such edited and formatted copy would be provided to the parties and their legal advisor upon the resumption of work.
So what page?
Sorry, this is at page 109 of the bundle. So this is an affidavit evidence which states that there was an undertaking on the part of the arbitrator that the award would be provided later on, and that undertaking, it would be provided later on and upon resumption of work, and that undertaking was accepted by one and all. So here we talk about the arbitrator undertaking and the respondent and the parties accepting. So this is where we have the contract, and that was recorded in the minutes. And also the judgment, just briefly, I mean, it doesn't talk about judicial contract, but it relies on the evidence put forward by the parties in relation to the exchange of email and the chronology. So ultimately, the facts relied on to prove judicial contract and tacit prorogation are the same. Why? If the board is not agreeable that this is not a new point and it was not addressed before the court, why should the board admit this new point? So relying on the case of Flashbird and Baker, we submit that there is no injustice done in the present case to allow the point on judicial contract, because all the arguments relied on in support have already been canvassed under tacit prorogation, and it is really the manner in which the legal principle is formulated which is different. There is no difference in the substance of the arguments. Also, the board would not be in a better position if the Supreme Court had given its view on the judicial contract, because the Supreme Court did not proceed with dealing with tacit prorogation. It stopped there. So had judicial contract been before the court, presumably the court would not have addressed it anyway. So there is no injustice in that sense, because the board would not have been able to benefit from the Supreme Court's finding. Unless I can be of assistance to the board, these are my submissions.
Thank you very much.
My Lord, for the purpose of my submissions today, and for the sake of simplicity, I shall be referring the appellant at times as Alphamix and the respondent as a district council, given that it was the other way around in the court below. My Lord, you are in presence of the district council submission, written case rather, and I do not propose to repeat them. In the light of the submissions of my friends today, both orally and what had been set out in the written case, I intend to address the board as follows, if I may. Very briefly, about the noticeable contrast between the submissions, the contention of Alphamix before the Supreme Court and now before the board. Secondly, to go back on the fundamentals of my annulment application, of my client's annulment application. In other words, the case that the district council was advancing in trying to get the award annulled. And in doing so, I'm going to respond to what has been grouped by my learned friends on the other side as ground A, B, D, and G. These grounds appearing as grounds in the application for leave, because we know it's a bit confusing afterwards, because it was interchanged. And then to address the issue of whether, which has and tacit recondition, grounds H and E, and finally, the legal framework governing an arbitration. And while doing it, I'll have some miscellaneous issues which I will have to touch upon in reply to what I've heard today. First, when my learned friend, maybe I can start with the last point being made, when my learned friend referred to the authority of doctrinal authority of Seraglini, and there I understand she referred to the no objection that counsel made on the 31st of December 18, page 72 of the brief. Both counsels state that they had no objection. I wish just to make the board understand, and you'll also understand, in France, unlike Mauritius, counsel, avocat, they have the dual capacity of attorneys, avoués, and avocat. This, in Mauritius, with the branches of the profession, there's a duality. We have barristers, we call avocats, and we have solicitors, avoués, and the counsel, avocat, they don't have a mandat ad litem, so they cannot bind a party. This is a fundamental difference when we read what has been referred to by my learned friend when citing Siraglini, as if saying that there was, therefore, a binding consent. I wanted just to underline this. Both counsel, and no mention is being made here of the attorney doing the same thing or the party is doing the same thing.
But if counsel says that they have no objection, then they're taken to have their client's authority to say that, unless the contrary is shown.
Yes, but what I wanted to say, from a strict legal point of view, they don't bind their parties.
But we've seen a number of instances where the minutes of a meeting record that counsel agree that the arbitrator's mandate should be extended. Are you saying that they weren't binding?
I will come to that, but because I think on most of these cases, the parties did agree, and there was even a document, an instrument for the extension that was made, and this is quite important, and I'll come to that in a moment if I may. The second thing I like to say, and I think it's very important, Mr. Arbitrator, the second one, Mr. Benjamin Joseph, he was struggling to deliver, to render his award before the expiry of his mandate. That was on the 31st. It had been extended quite a few times, on the 31st of December, 18. We know, and it has been underlined, that he was ill, had flu. He could not even he had to deliver it at 10, but then it was postponed. They asked for parties to come back at 12. And then finally at 13:10, they met at the chambers of the arbitrator. And then he asked for permission, if I may say so, he asked for permission to be able to read only parts of it, the introductory part and the conclusive part, which was obviously agreeable by all parties, and he did so. In his mind, and I'm quite persuaded of that, in his mind, the award was then and there delivered. Unsigned, unedited, unformatted. My learned junior was appearing in the case at that moment. He had not appeared all throughout. He started, his services were written, I think, as from 2017. My learned junior requested a copy, and obviously the arbitrator said, yes, we'll get a copy. And then there is this question about the later on. What I say is, and I want to submit, is that in fact, in the mind of the arbitrator, the exercise was completed, was consumed. Whatever he was going to circulate afterwards, the unedited, unsigned, unformatted copy, which was circulated 3/4 of an hour later, 13:56, through the email of his secretary. But for him, this was, because it had been requested, he said, we are going to circulate it. And for him, there was no question on that very day of doing the formatting, the editing, and the signing. And for him, there was no question of extending his mandate. He had struggled. If we read the sequence, it was postponed quite a few times because of personal predicament, he said. And this is in writing and is borne out of the record.
Well, what you're saying seems to be a point against you. Everybody understood that it was sufficient that he would read the bits he did, send the draft, and provide the signed award later. And that was the way in which the business was concluded on that day.
But this is not the law. And my learned friend does agree with that one, because, and this is where we can see the battle in the court below.
But he conducted himself on the basis that that was what was being agreed, and that was the impression he gave.
Yes.
But he was content with that. So you can't afterwards come along and say, oh, no, we've actually, although we may have agreed that and given that impression, we'd now like to say that the award is irregular. You've agreed to the contrary.
And I didn't say we agreed to the contrary, if I may. I'm trying to read the mind of the arbitrator, knowing that there was a guillotine date. He had to do his work. He had to finish his mandate. He had asked for some extension quite a few times. He was struggling to deliver and render the award. In his mind, it had been rendered, but this is not the law. And my friend do concede that lack of signature is fatal, and this is a code of procedure civil.
Well, is it your case that the counsel who was there on your part realised that was what the arbitrator thought, but thought, well, I better keep quiet about this, because then I'll be able to come along afterwards and complain that the award was out of time?
I mean, this is, I heard my learned friend, and I think being quite bold, if I may say so, in suggesting bad faith, not only on the part, my understanding is correct, of the party, that is my client, the district council, and also maybe on the legal advisors. And I think this is going very, very far.
Well, exactly. So what I would think that the correct interpretation is that your client's representatives there understood and were agreeable at that stage with the course of action being followed. The only alternative is that they were acting in bad faith, which is not an inference one would wish to draw.
I beg to try to explain myself and disagree with such a suggestion, my lord.
Well, certainly thus far, our submission is that the arbitrator, for his part, thought he'd done the job.
Yes.
And that was apparent to everyody then?
I don't know. I wasn't there. I can't know. But
there was nothing. Everything you rely on to say that was known to the parties then, wasn't it?
My lord, if I may be allowed, my involvement started post-expiry date.
Well, you're presuming to read the mind of the arbitrator, so I assume you're relying on facts that were known to the parties at the time.
When I was not involved at all. In fact, my lord, I don't even know the underlying facts of this arbitration, the merits of it. I don't know even. And this was not my services were not retained. My services were retained to say whether, because there was no appeal, whether there was a possibility of an annulment proceeding. And then when I looked at it, and I thought there was one, for the two reasons I gave, which is the two limbs of my motion. The purported award being unsigned, and this is fatal. And my learned friend who appeared, Mr. Domingue, who appeared before the Supreme Court, this was his sole contention. He never touched on the 2 points, the primary point being raised today by my friends on the other side. That is, that in fact between 2 o'clock and midnight on New Year's Eve, while having flu, the arbitrator sat and wrote down, edited, formatted, signed and put it in his drawer. No. Why I say in the mind, my lord, of the arbitrator, he had done his job. There was no need to sign it. There was no need to edit it. For him, this work was finished, but it was not finished. Legally, he was wrong.
If Mr. Mamaji had said, no, we've got to have a signed copy, and the arbitrator signed what he just read out, would he have had the power to make editorial corrections afterwards?
It can, yes. It is possible, obviously, like just to correct, but nothing of substance.
Mm-hmm.
This is a possibility, yes. So I wanted to put quite a lot of emphasis on this because I think it is important. It is important, and all the other points being raised this morning must be looked at with that scene in mind, if I may express myself like that. It is important. So, when the arbitrator, he probably retired to his home on New Year's, and I heard my learned friend say that obviously in Mauritius we don't work on the 31st till very late, and that is quite true. It is a festive moment, and he retired. It is not likely that Mr. Joseph went back home and did what we understand he did, and which is now formed part of the primary case, which was not at all before the Supreme Court and the judges of the Supreme Court. So with this little background, I wanted also very quickly to say, and I hinted on it, what I know about the merits of this case. The only thing I know about the merits of this case is what your lordships also know about. That is what is borne out in the affidavit in support of our motion for annulment, which is at page 7 of the brief. And what we know is that there was a contract for a market for £400,000 to 22 million rupees roughly, and that there had been several interim awards by the first arbitrator, Mr. Vélien, and we don't even know what was the financial impact of these interim part awards, as sometimes we call them. And then there was the second arbitrator, Mr. Joseph. He also delivered part awards. In fact, he delivered 3 interim awards. And you will see that by the time he came with his final award, over and above the 20 million rupees, that is £400,000 equivalent roughly, there had been 103 million rupees that had been paid over and above. That is almost not far from 2 million more. £2 million for a contract of 400,000, but that was obviously not the end of it. All these figures can be seen, that is what I'm talking about, they can be seen in the final award itself. And at page 89, we can see that under item 1, at page 89, there were 73 million rupees. Plus
what is the significance of this?
What is what?
What is the significance of this point?
The significance is what
your clients have had a lot of money to pay already, so they shouldn't have to pay any more, or what?
The significance of this is I wanted just to highlight the fact that what was obviously at stake here, and then there was this final award, and which we understand, and this is borne out of a record, was for an enormous sum of rupees.
Why did your clients decline the offer of the Supreme Court to decide it and put an end to the thing?
Because it's my client's right. We asked for it. In fact, you will see from there were a few adjournments. Okay, there were a few adjournments. The suggestion was made to us. I said, yes, we'll try to find it out. But obviously, looking at, and we tried to find a solution. We really tried to find a solution. This is borne out of the record. But unfortunately, we didn't reach a solution. And we couldn't settle the matter before the board. And they also eagerly tried to have it settled. But at the end of the day, they had to deliver a judgment. And they had to deliver a judgment on what was pleaded, what was submitted in front of them. And this is why I said the divergence between the submissions of Alphamix in the court below and the one which is now before the board. Both in the written submission and in his oral submission, my friend Domain, who appeared and argued on behalf of Alphamix, he stated that in fact what we had styled the purported award, the purported award being the one which had been read over at 13:06 on the 31st, and which had been circulated 3/4 of an hour later, 13:56. This is the purported award. And for him, the purported award, like I was saying, the mind of this was the final valid award. So for him, he fought the case along this. And
so are you submitting that they shouldn't be allowed to make the arguments they're making now?
I'm saying that they have already made their argument. What I'm saying is that the board, in my humble view, must consider this in the light of the fact that the Supreme Court was not apprised of these issues. And we all know the cursus usually, the practice is that you won't go, you usually will, your lordship will want that to know the considerations given by the Supreme Court on those matters, and therefore, when my learned friend said that, and she tried to capitalize on what was written by the co-respondent, and this is quite important. We brought in the correspondent, the arbitrator, because we thought it was important for him to enlighten the court, to clarify matters. And I think he could have. But then the stand taken by him, he was not going to adduce any evidence. There was a written submission which was made and filed, and counsel for the arbitrator was repeatedly asking to be removed. And after we considered the matter, and in view of his request to be so removed, we decided that therefore to allow him to not to continue with the proceedings. And when he was removed, my learned friend, appearing then for Alphamix, did not object. So
you're saying at the hearing he didn't attend the whole hearing, or?
He made one appearance or two, but right. when the oral submissions were finally given, I can't remember exactly the pagination where it is, when it was given, he was no longer a party.
But you still addressed his arguments, didn't you, in your oral submissions?
I beg your pardon?
You addressed his argument about tacit prorogation in particular in your oral submissions.
I had to, because this was made by the other side. I didn't address it because it had been ushered in somewhere, somehow, by the correspondent, then the arbitrator. I did it because this was their contention, their primary case, and then
the tacit prorogation was? I thought it wasn't.
Oh yes, they have no. Before the court below, neither.
I'm referring to page 205 and 6, which we were taken to, of the transcript before the Supreme Court in the proceedings on the 11th of June. And I understand that on page 205, MS 205, it's you who's addressing the court and referring to the written submissions of the co-respondent. If that's wrong, then perhaps you can correct me.
Oh, yes.
So you are referring to the issue of tacit prolongation, as it's put, which has been analysed in a more thorough way by my learned friend, and you then go on to deal with it. So,
Quite right.
so you presumably accept that that was an issue before the Supreme Court?
Yes. Because I probably now with hindsight I didn't want to leave any stone unturned, and because somehow this had been brought in, I did thought it wise, appropriate to say a few words on it, and so that the picture become complete. But there was this, I agree, but.
Well, are you saying they can't argue it now?
I'm not saying that they can't argue it now. They have already argued, by the way. But what I'm suggesting, my lord, is that
the arbitrator was no longer a party at that point.
I beg your pardon?
Is your submission that the arbitrator was no longer a party at that point? The co-respondent was no longer a party?
It was no longer a party.
Yeah.
Right.
At the time we ushered oral submission, it was no longer a party. Quite right. But what I'll try to answer the remark of your lordship in relation whether I'm taking objection now or not. I'm not taking objection, but however, I do submit that this striking dissimilarity with what was said before and what was canvassed before the Supreme Court and what now is before the board and your lordships is important to consider. And when you are going to consider these points, you must analyze the fact that these, mostly, I would say now, mostly the primary, which has been termed the primary case, that is the point being made that the award was signed by the arbitrator between 2 o'clock and midnight on the 31st. This had never been said by anybody.
I don't think they are saying that, if I understood it right. They're saying there's a legal presumption that it was signed in that time, and there's no evidence to contradict it.
Again, I will come to
which is a rather different point.
Yes, but the fact remains, my lord, that it was not. It is a point being raised now, obviously, which should have been raised before the court below, if it was that important. And now we are going to analyze the contention of the other side on that point. That is, that this case of legal presumption, which, by the way, is common sense. When an instrument has a signature and a date, common sense indicates that it was signed on that date. But I will be inviting in a moment your lordship to look at the circumstances to be able to show whether this is plausible.
So are you agreeing that there is such a presumption?
Yes, there is a presumption. This is common sense. There is a presumption. But the fact remains, and this is where I suggest it was important to have clarification from the arbitrator whether he had done so, and we had put him into cause, and he had the liberty of clarifying, but he decided not to. And again, I apologize for repeating myself, and he did not, because for him everything was consumed at 13:10, and what was circulated 3/4 an hour later. For him, that was the end of the matter. So there was no question for him of going any further.
So your primary submission is that the arbitrator was just acting on a fundamental mistake of law,
Yes.
because he believed that a signature was not required.
Yes. this being a requirement of the Civil Procedure Code in France and in Mauritius.
But it was understood he would have to sign it and that it would be provided in edited form as reasonably possible. Is that a fair
Sorry, I didn't.
Is that a fair summary? But he did understand that it would be signed.
Yes.
And that it would presumably then be provided to the parties as soon as reasonably possible.
Yes. But from a temporal point of view, he didn't sign it, and his mandate was over when he signed it. And this is crucial, and this is very important. And since you are on the... I heard my learned friend, Julianne, submitting on the fact, and overseer, when we should talk about, and I'll come back to it, but since I'm standing and thinking of it right now, as if there were questions that were put to her in relation to whether it was a reasonable time after New Year's Eve, and whether there was ambiguity or not. When that be, first of all, it is interesting to note that on the other side, and rightly so, they admit that there was ambiguity. My learned friend repeated it. They admit that there was ambiguity.
Well, now, if you're going to move on to that, it may be convenient to do that at 2 o'clock. It's 1 o'clock now, and
oh yes,
and I think we will rise and resume at 2.